Eu vou tirar a mascarilla para agora.
Sí. Empiezo tú.
Muy buen día, muy buenos días. Creo que me escuchan bien.
Good morning. I believe you can hear me. It's not easy to hear me well, but thank you for being with us. You are the true players in this week. We only facilitate as much as possible, but the merit of the final result corresponds to everyone who is here with us and those who are following us at a distance. Right now, the political dialogue between the EU and Latin America has been conditioned by pandemics and distance, and this is probably the higher level that we are doing today. These meetings of justice is an approach of both regions, and the collaboration between colleagues and friends from Latin America and the European Union. We have the cooperation at an operational level, and we're talking about joint teams, where some of these teams have a reason that we're going to work today. We have other levels of cooperation, regionally, technical and tactical. We are talking about operations, contact points with the Eurojust, and the work with the impact on the security of the European Union and multidisciplinary that also have to do with the justice, and this is the strategic and tactical level. The political level between the two regions, and besides pioneers, and we can replicate in other instances such as the internally or the environment or priorities that we can add. So congratulations, because you are the first ones to inaugurate this path, and with luck, in the end, we'll establish a work group at the technical and tactical level that is permanent between the EU and Latin America, that has content of priorities and that will mark these high-level meetings. So thank you very much and good morning.
Muy buenos días a todas y todos.
Good morning, everyone. As Juan was saying, this is not a meeting like the other ones. We need to leave this meeting with very concrete outcomes. We come from a complicated period where mostly organized crime has followed us and has taken advantage with the pandemic to develop new modes for crimes and infractions, and we are probably more delayed than before, and we need to react. International cooperation. We need to leave this meeting with concrete advancements because international cooperation in many cases is like throwing a bottle to the sea and not knowing where and how it will reach shore. In infractions, we are in a tunnel. We don't know when or if we are going to exit it. So it is something we need to discuss and find ways of improving cooperation systems internationally throughout these days. We'll also talk about high importance themes, but both Antonio and Gloria will go into details. So it's an opportunity for everyone, the participants and the people who are following us at a distance, and we believe it's a major opportunity to see each other personally. I will mention a motto from a Finnish company, connecting people. This is what we are actually doing, because we know that cooperation is that. It's to join, to link people, and with luck, we could inclusively work in the future. So thank you very much, and good morning.
Bom dia. Muito bem-vindos a Lisboa, é a minha cidade.
Good morning and welcome to Lisbon. It's my city. We are all together here because we have a common objective, which is fighting organized crime. We belong to two regions that share principles and cultural principles and also organized crime. And as they share that organized crime, that helps us in fighting organized crime. And organized crime needs to be fought through cooperation, international cooperation. And this international cooperation is essential to have a successful fight on organized crime. So we need to move forward with the reinforcement of that cooperation between both regions. We have here the justice institutions that are more important in Latin America, and we have the justice institutions of the European Union and Eurojust. We need to understand each other. We need to create alliances. We need to share principles, and we need to develop ourselves in many fields. This meeting of ours, and if you look at the panels are the result of a work that we've been conducting with institutions. It's not by chance that these themes are chosen. These themes are the presentation of a work that we have been developing with the institutions that are present, and also with the European Union and the Eurojust, for instance. So it's this work that we'll now present, but it's not a final work. This is a route, and this is only a milestone in this route. We have lots to go, but we have good perspectives that this route will be fruitful. We'll have themes, as you can see in the agenda, such as environmental crime. Environmental crime is a crime that is being developing globally and whose proceeds are becoming important. We need to join in a common legislation. We need to distribute or to share investigation techniques. We have the whole world fighting the crime against the environment, and we must do it together. The recover of the proceeds from crime. Criminal organizations only can be fought if we decapitalize them. We need to advance in the recovery of assets. And international cooperation is very important because a crime happens in one country, but washing happens in another one. And if we don't cooperate, it's not possible to recover these assets. The digital evidence, the independence of the judicial power, new technologies. So these are the themes of the agenda, and the themes we'll be debating throughout these 3 days, and I hope and I believe that we'll reach important conclusions, we'll open perspectives for a future route, and I think it was Xavier and Juan who said that we must leave here with a follow-up commission, something solid, and the ideas are very good. It's very good, as we say, to distribute and to share ideas, but we need to go beyond ideas. So thank you, everyone, and I'll pass the floor now to my colleague Antonio Holm, who is a very good speaker, much better than I.
Sí, bueno, buenos días y lo primero decir que estoy muy orgulloso.
Good morning. I'm very proud to be here. The first thing I want to say, and to be able to reach the institutional level that, apart from the friendship that already bonds us, many of us, some are older or newer friends, but this is actually a moment and a milestone because in spite of the pandemic, we are are here with a program with very high institutional level, and this is extremely important. Having said this, I must say that this event was very demanding in terms of programming, the whole team, and I want to thank the organizational team of communication and logistics because they made a huge effort for us to be here today. Having said this, I want to say that even though we have an agenda which is very complex, this is not work that is starting here. This program started in 2007, and it's been accompanied by many activities and reports that somehow group the evolution of the contents, regional institutions, national institutions, where you all are involved. So I won't go into details now regarding the agenda, as already Gloria mentioned, but everyone mentioned already the importance of each and every one of the elements here, because there are statements and lots of world statements that say that it is necessary to collect or to recover the assets that prove the crime. But to do it, we need to have a cooperation agenda. When we talk about the recovery of assets related to crime, that has to do with all those who research, investigate during the process stage, the administrations that need to hold with all of them, and we require agreements to make all of these in an articulated way, as we've been hearing, in a sustainable way too. We need agreements, and agreements cannot be only what we're talking about. We're talking about joint investigation teams, digital evidence, and we're talking about a number of elements that are being worked at other levels, such as, well, as Gil Botero mentioned in his opening session in the morning. But it's all of this is important, but we need to take these tools so that we can face the new challenges, so that we can overcome these new challenges. We talked about digital evidence, but more than that, environmental crimes, that is the present, is not the future. And we need to work all these and introduce it in our respective agendas. And as Gloria said, and she's right, that we need to leave with results. When you organize an event, everyone knows that we know that we like people to work in our meetings. We are quite demanding to ourselves, but we want things to happen and to prosper. It's very important. So each panel has a number of assistants working for a conclusion reports so that we can leave here with agreements that can be welcomed by institutions in both continents. And we are also playing in the same league. We play with juridical culture principles that are common, with needs that affect us all equally. And this requires to do as much as possible to make it all sustainable. We need to understand what we're doing and what works, but also something that we are talking about and have been discussing for 10 to 15 days. We need to prepare a document that establishes the basis for a sustainable future work, whether we have the program or not. But when these institutions that deserve all the support so that they can work and they can continue with their work. And I will end now so that we'll have the first table. Everyone will follow the same scheme. So we'll have a moderator who was already working, anticipating the different work points of each panel, and then the different intervenants. And everything is based on the fact that we have no speeches here. What we have is dialogue. We want everyone to collaborate and participate. We are aware that it is preferable to sit at a round table. Of course, with the pandemic difficulties, we can't have a round table, so we talk in this fashion as we have it in our as we are here. So we're not around the same table, but please raise your hands and if you want to take the floor and have a good work. And let's do it.
Tenemos que esperar. Vale. O sea, tenemos que esperar 15 minutos. Es que yo me extiendo, cuando me dejan, yo me extiendo, ¿eh? Y dije...
If I'm allowed, I will keep speaking. I tried to be short this time, but... So it was a sort of a monologue. The objective is not for me to speak, it's for everyone. So this is a round table, even though we have this seating arrangement. But we need to define conclusions, but in order to define these conclusions, we need to have maybe some personal meeting between AIMP, CONGIB, Ameripol, maybe to have a meeting. As we have 15 minutes, maybe we could ask if someone has any doubts, any issues, any clarification, requirements, with whom to work. Maybe that could be interesting so that everyone understands how this has been going on, because we've been working with many of you. So this is a problem working with two idioms. So I end up not knowing whether I should speak Portuguese or Spanish. But in Portugal, it doesn't make sense for me to speak, in Portugal, to speak Spanish for Portuguese as well. But then it's a habit. So if, because we have some time, if someone wants to ask a question on how we've been working, about the program, we are open to receive from your side also. So let us wait a little bit then, and then you can speak, maybe. So let us wait a couple of minutes. I apologize for the delay. We'll wait for a couple of minutes.
Pues es eso, ¿no? Os ponéis de acuerdo por CONGIB, por AYAM, por Cumbre, a ver con quién podemos tener alguna reunión en una mesa.
Let's see who we could have a meeting with, and we could have draft conclusions then. Between the panels, we can find a moment, we'll decide who, and then we'll talk. I'm sorry.
Señor Antonio, buenos días. Buenos días, ¿me escucha?
¿Qué tal? Sí, perfecto. ¿Usted me escucha?
Pues vamos a conectar ya con usted, ¿de acuerdo? No tape su cámara ni el micrófono, ¿de acuerdo?
¿Lo dejo todo abierto? Sí, le escuché. Dejo abierto el micrófono y la cámara, ¿cierto? Pero todavía no es porque mi turno es en un panel que modera un fiscal. ¿Ah? Claro, pero es que yo no parto hablando, a eso me refiero, parte hablando un moderador del panel. Que en ese panel de recuperación de activos parte hablando un fiscal portugués que es el moderador del panel, no yo. ¿Cómo? Eso, exacto. Exactamente. Yo espero que me den el pase y ahí hablo, exacto. Vale.
Eh,
Hola. Perfecto. Vale.
Adelante, por favor, como quiera. Pues siéntese aquí, por ejemplo. Los dos y ya, pues para hablar. Sí, vamos a dar comienzo a la primera.
Let's start the first roundtable. I'm going to introduce people here. We have the moderator, Mr. Ivo Rodrigues, is a prosecutor of the prosecutor's office in Portugal, and Mr. Cecilia Pérez Ribe, Minister of Justice of Paraguay. Welcome. Ideally, when we talk about retrieval of assets, there's 4 phases to obtain the assets related to a crime. First is the identification location of the assets. The second phase, we have a judicial decision in which is in some countries, we talk about the seizure of assets, others the apprehension or confiscation or embargo of assets. We have several terms used to speak about the same. That is to seize, to confiscate the assets. As Mr. Churchill said, America and England are 2 countries separated by an ocean, separate in the same language by an ocean. We have the same situation, and some of the countries in the Latin American countries, we have a system of dominion extension in which they agree with the extension of the dominion that's adjudicated to awarded to the state, and others use a system of confiscation of assets for the justice. There's small differences in the terminology that sometimes it makes it difficult. So they don't have they're not duly articulated, and also some limitations for the transfer of the assets. And just to say what that's Mr. Rodrigues is going to speak in more detail, because he works in this team for many years, and he's working in the system for the location to establish the basis. So the different types of national registers, there's more than 30 registers that are liable to be seized or apprehended, and can be accessible in a quick way from the police to the public ministry, public prosecution, and we are working because we need to work in every country how to have access and what conditions we should have. So there's IT passerelle that will carry all the required information. And we are working, this is might be important with CONGIB, because there are some countries that have management entities for the management of assets deriving from crimes, and then there's not a network that can do the delivery of those. So the systems that exist in each country can shine, and for that we need good practice at that level, and we are working on that. So we need a system that allows the execution of trans-border decisions. So we have to work in measures of coordinations so that in the initial phase and at the phase of the assets confiscation, this can be very fluid, can flow easily from one execution to another. So it can be in a coherent way. So we need the systems to be in harmony, so everything can go in a flow. So because sometimes it gets stuck at a certain point. So we think that the first table should be oriented in that direction. So Dr. Elliott, thank you for being here, and you have the floor. Good morning, everyone. Allow me, before everything, to welcome you to Portugal, those that are here personally, and to welcome you also to this first panel of the work agenda for this conference. Those that are assisting through video conference also would like to welcome them from this first work panel, which has the objective to reflect upon the possibility of implementing new policies, of finding new strategies, new paths when recovering assets. And for this reflection, we counted with an element of eye level, with the deep knowledge of this matter, and will also give us a very relevant contribution in this task of defining new paths, new alternative paths in the recovery of assets. And I would start by introducing the elements of this panel, starting with the Minister of Justice of Paraguay, Cecilia Perez Reve, that honors us with her presence, and also a representative of the Fiscal Matters of Chile, that is with us in the video conference. I think he's connected already, so my welcome to Chile, and also to introduce the team of this panel. And with all the intervening parties, I have no other wish than to try to frame this matter, try to frame this discipline, leaving some challenge, also here and there some provocation for the debate. Because this is a huge topic to talk about new policies regarding the recovery of assets is the same as talking about new policies about criminal proceedings. There's a huge set of parts and proceedings and regarding this line of reflection, which requires some capacity to shorten it. And because this is a huge topic and the time to deal with it is very limited, I will start by waiving the traditional references to the importance of the recovery of assets. I think that at this moment we are all in agreement to signal that the importance of the recovery of assets is almost like to appealing to a common sentence. So it's like a common idea. I don't think this is no novelty. So there's no state in the world, at least anywhere the rule of law governs, that doesn't think that this is indispensable to guaranteeing this way that the crime does not compensate, and also preventing that these funds, illegal funds, will contaminate the illegal economy. This ensures that the recovery of assets, especially the confiscation of the economical advantages obtained through crime, it's a very effective tool to fight against the crime, especially the most severe ones, the economic and organized crime. It's also a principle that I would consider as unquestionable. And if this is like that, if the importance of the recovery of assets is clear, what is the reason that the levels of efficacy of the state is so low? Why? Where are we failing? We are failing in some aspects, and it's important to try to identify where this source of problems is. And I'm saying that we are failing in this matter because according to a study quite recent from Europol, as a reference, in 2019, the revenues of criminality within the European Union, focusing in the Union, in 2019 went to 139 billion euros. And this is a bad news. This statement is quite bad, but there's a worse one, which is the fact that only 2% of this global amount is the object of some patrimonial measures. Only 1% are confiscated. And if only 1% is being confiscated, we are failing for sure. It is required that a definition of a new political measure. And so we should signal the first question, what can be done to revert, to go against this dramatic finding? So what should we do, and what is in our hands to change? And there's many questions, but maybe it will be worth to look for answers in this matter. In my perspective, there's a global commitment that should be done, not only from the states, but also from the entities that assume the judicial authority, namely those that are represented in this that gather together regarding this common cause and will work on this matter. I think this is absolutely indispensable that true culture of recovery of assets is created. In most cases, this is not the problem in Portugal, and I think it's not in most countries that are in this conference. So it's not a lack of laws or the lack of quality of the laws. The laws exist, but sometimes are not quite adequate to fulfill their objective, and they need to be applied in an efficient, effective way, and guided by the principles that govern this matter. The justice institution here represented have a very important role in this matter, as they are in the privileged position to implement this indispensable culture of the recovery of assets. But how can this be done? How do you implement this culture? What would be the paths to so that this true culture is implemented? I do not know. This will be the most relevant question in this matter. But there won't be a silver bullet, and you just have to press the switch. But there will be some ways, some solutions to solve this problem. Maybe some requirements for training, the reformulation of the master courses, and the need of specific cooperation among states, considering the different modalities of the different jurisdictions, and the internal recovery in each country among the entities that also intervene in the recovery of assets, and among many other solutions that should start from commitment the future that will be signed upon. But one thing is sure, the strategy addressed for the recovery of assets should start by the need to analyze the criminal context that exists all over the world, and to recognize this principle that criminality that goes against the fundamental interests of the unit is not the old one of subsistence. It's a new phenomenon that has been called the real criminality of power. And if criminality changed, the strategies and the mechanism used to fight it also have to change. We have to adapt, and we have to know how to adapt to the new challenges. The medicines of the past showed that they were not effective to solve the future problems, and even the present ones. That's why the maintenance of a strategy, the old one that is outdated, that's exclusively guided for the criminal, that limits the response of the state with the application of a sentence. This benefits only the criminal individuals, and also affects the individuals that are law-abiding citizens. So we need that it should be addressed to the criminal accountability only is naive, and the institutions have to be fair but cannot be naive. We have the crimes related to cyber crimes and have increased exponentially, especially new opportunities came up with this in this criminal trade. So in accordance with some studies regarding the perception of corruption, drug trafficking, human beings trafficking, all the organized crime does not show any signs of slowing down, and thefts and everything, it's still like mass crimes. And we have to ask what these crimes have in common. Where are they the same? What do they share? And all these criminal phenomena that are so diversified, such as small theft or something more complex from organized crime, share that they, from the perspective of those who practice the crimes, a business, because they exist because they're profitable. And to eliminate that profit, that economic advantage, is the only way, from my point of view, to fight against what generates it. So this would be, from my perspective, the only way of fighting the illness, and not just to treat the symptoms. All the other strategies are, in my perspective, an attempt to solve the consequences that are caused by this criminal phenomenon that have the target, the profitability. And more than the reformulation of a thought matrix, it also requires a reformulation of an acting matrix from the entities that are involved, and those that have the capacity to influence the criminal sentences. And this is quite demanding work that has to be done, and we should look, try to find, and this is also the challenges, that within the scope of our functional scope of each entity represented should have some influence in this objective. We should also underline that this problem led that only 1% of the advantages of the crime are seized, and it's not enough. So it's not just, we should not have just a theoretical statement saying that we should do that. We have also to understand the process for the recovery of assets. And at the beginning of this panel, it was talked that the challenge would be like starting from a more technical perspective, try to understand what can be improved in each stage, to understand the singularities of each sentence and look within them to find solutions for what in this moment works at a very satisfactory way. And in this first stage would be the identification, the location phase, and then the investigation either of the assets and financial, and the success of the application of the recovery of the assets depends on the first phase, depends from the capacity of identifying and locating the assets that can be seized. This would be a very relevant phase of this from this perspective. And also in this first phase are also relevant the assets and financial, which is different, is oriented to recover assets, and the other one is guided for the application of a sentence to identify the checking of the elements of the crime at stake. So the first phase of identification and location are located to the training of the magistrates in order to ensure that those that intervene in the recovery of assets know how to identify the assets that can be confiscated and know the juridical instruments for that purpose. This empowerment and knowledge are really needed for this. And also on the stage, it will be the need to ensure the access to information of a set of databases that are adequate, adequate access to the bank institutions, the tax entity. There's a set of specific data regarding the recovery of assets that are indispensable for this phase of identification and location. And at the end, still regarding the elements that might be relevant for this phase, it's also indispensable the eventual creation, if it doesn't exist, or to ensure the existence of an entity and specialized unit developing an investigation regarding the recovery of assets that has the capacity, either an internal or international way, namely an office of recovery of assets with exclusive competence, if not exclusive, at least specialized regarding the assets and financial recovery. After this first phase, I try to be very short in placing this. There's a second phase that will be the phase of the seizure. And this phase, it's closely connected to the success of the first one. The seizure, it's the capacity to apply a measure that is about the assets that in the first phase were identified as being liable to be confiscated in favor of the state. This phase corresponds to that one within the scope of the Justice Departments, will be more relevant, might be more intense. And the special relevance of this phase of the seizure results from the need to consider a double perspective. First, to consider that it's precisely in this stage that the assets are somehow affected, that are the questions regarding the third parties of good faith, criteria to protect the victims, either in the criminal entities and with the recovery of assets. Because after the assets are recovered, then there's the obligation of the state to ensure the custody of those assets, and also the creation of adequate mechanisms for the management of the actives that have been apprehended. As a third phase, we have the seizure, those that the assets are considered to be lost in favor of the state, in which the court declares the recovery of assets in favor of the state. In the fourth stage, it is recognized the existence might be considered autonomous stage as the phase where the assets considered lost are put under the sphere of the state. And in this fourth phase, there might be a fifth moment that corresponds to that in which the state decides about the destination or the management of the seized, recovered assets, and are in this the phase where the assets are seized, that the criminal individuals are faced with this challenge of losing their the profits, to put the agents of the crime in the state where they would be if the crime had not been done. So it's important that the state show that in this phase that the crime is not profitable. So with that decision of the decision to seize the assets, they are recovered because they are returned to those that belong to the state. The advantage of the crime does not belong to the criminal individuals, and they are recovered because they are returned to those they belong to, and that's why this is very happy phase. And the execution of the assets also has important challenges. Those at the level of the assets recovery, the definition of rules regarding the sharing of distribution of assets when there's been some judicial sentence in this matter, and also the definition of rules regarding the assets at the internal level, the level of distribution and things. I think it must be defined.
E desta forma, enfim,
And in this way, therefore, I tried to highlight some reflection lines. There is a whole set of paths in terms of recovery of assets that can be followed. I try to organize these with these moments chronologically and logically oriented, but of course the intervenients in the panel are free to choose these proposals for reflection or others that you deem suitable. So following the order in the program, so I will pass the floor to the Minister of Justice of Paraguay, so to tell us about your reflections on this subject. So good morning, everyone. Thank you, Dr. Rodrigues, for your explanations. I would like to thank everyone for the invitation to participate and the participation of the Ministry of Justice of Paraguay in this event. And we've been working for some time about these interests in our region and these questions. So Antonio asked us to be short. I hope I won't extend my allocated time, and I would like to share some of our concerns about these issues. First, in the concrete situation of Paraguay, we have, with the help exactly of ELPACT, we have defined and regulated the functioning of the Secretary of State for seized or forfeited assets. It's an institution that we have a responsible person who's the executive secretary of the minister, and in legislation in Paraguay, we have all the rules and norms and regulations defined, but in practice we find some difficulties. One of those is the seizure by the ministry, by the public prosecutor or the justice, who have the responsibility to define the recovery of assets. From that moment on, then begins SENABI administering the assets, and then from the moment they are seized, then how to deal with them. But then the identification of assets during the investigation stage belongs to the public prosecutor, and not always the seized assets come to SENAPICO or are assets that are really confiscated. So there is a cut internally in this joint work in specialized units of the public prosecutor, taking into account, and it's important to mention this, that the specialized units for crime that are part or that are working on organized crime, sometimes they work in tight compartments with other, well, they have also corruption, public corruption, and other types of crime. And so the technical team would have the necessary knowledge to identify those assets that are suspected to be the product or the proceeds or part of the proceeds of transnational crime. So on this question, I believe that we need to have joint work, mostly on these cases where you have, for instance, transfer of assets with other data, because money laundering, for instance, usually it crosses borders. And there are very important cases, for instance, in Paraguay right now that are connected to money laundering. And because we are close, well, we have this figure of the autonomous commissioner, and so we have people that right now are being processed or sued in Paraguay and that are still dependent from extradition from other countries, or the knowledge that they wouldn't have extradition because in the origin country they would be arrested, and then there is no extradition. Then we have a big problem because we have some laws of autonomy that are not being applied. The law is regulated and defined, but then there is a fear, a sort of fear to open a door that could affect mostly the facts of public corruption. So there is a concern in leaving or opening a precedent. And I would like to put this on this table and to mention here that the need that we have for the proceeds of crime not to go on creating profits for the accused, sometimes the sentenced, or when the sentence has not yet been issued. So this makes it last throughout the whole criminal process. So we have to guarantee to people that the resolution will happen within a reasonable deadline because of defense issues, and also because the ongoing defense, or the continuing enjoyment of the proceeds of organized crime. So this during the detention stage. The first stage, as Dr. Elliott defined in the procedures of an administration. But the problem today is not in the administration of assets. It's on how these assets reach this institution, either autonomous independent entity or an independent office from some state body that will generate a concern then when either we don't understand how the system of management of seized assets happens, or when you don't want to know about the functioning of the systems, not to go into stronger issues. So they can go on working. Sometimes they are related to drug trafficking, and if they want to keep owning what they consider the product of their labor in their legal defense. So also in terms of assets that need to be transferred, we have some difficulties, for instance, in defining how much corresponds to each state after the seizure. So we need to sign agreements on this because it creates another type of debate, because there are some institutions in our countries, like, for instance, in the case of Brazil, where an office exists for seized assets and other for forfeiture of assets. But who makes these agreements? That's a bureaucratic and internal issue in Brazil that hinders the materialization of these assets and the transfer of these assets. And when you still don't have a sentence, a conviction, but people that have been expelled or extradited today in Paraguay, where we, in our region, we, at least in the south, we act in a very similar way when it comes to the expulsion of those that come into our country irregularly and very often are connected to international organized crime. On the one hand, that could be, the person could be sued by a part of the crime in the national territory, but generally we opt by expulsion of the person, and in 90% of the case, these are people who have their assets in Paraguay, and sometimes you suspect that they are the product of a crime. And these assets are then abandoned there, well, in Paraguay, even though this is defined in the law, it's duly legislated. So we in Paraguay, we have the rules. Everything is legally defined and well defined. The question is how to act, how to decide. And so it is important to end these bureaucratic hurdles so that we can work, and in the case of our body, to be able to protect these assets from the political misfortunes that happen, well, in every country. So this office is seen as an office that administers lots of assets as though it were the owner. Well, the owner is the state, but we want to define this type of actions so that rules of the game won't be changed during the game. Nowadays in Paraguay, we're facing a danger of having the law changed. For instance, the law from 2017 has been changed. Now we are undergoing the second modification or amendment so that later on a single institution will be the beneficiary of the seized assets. And we know very well that these don't only come from drug trafficking or related crimes. There is a difficulty that either the state or society through the state to be paid by the proceeds of these criminal facts and actions. So we have the possibility today. I think that it could also happen in other countries, and I believe that this work should be enforced to reach our objectives. Otherwise, we'll need to hire more people. Thank you very much, Minister. It was a very valuable contribute because you started from the relevance of the need to create a true culture of assets recovery. I don't know. Now you mentioned the very important issues that I believe will allow a fruitful debate from the management of assets, but also problems related to eventual difficulties of cooperation because of different types of legislations and typology of seizure of assets, the way it is done, the traditional way. So very interesting points for reflection. I thank you deeply for what you mentioned and your comments. Now we'll then, I will pass the floor now to, I don't know if Antonio Segovia is with us. I would pass the floor to Antonio Segovia so that he can share with us his thoughts on this issue. So you have the floor.
Buenos días a todas y a todos.
Good morning, everyone. We can perfectly listen to you. Thank you. Very well. Good morning. Thank you very much for the wonderful introduction to this panel. Thank you to the Ministry of Justice of Portugal and to El Pacto program for the invitation to and the organization of this meeting that I believe it will be very rich in order to strengthen our relationships between Europe and Latin America. Thank you for having access to this space for debate. I'm sure it will be extremely beneficial. Regarding the theme of this panel, I would like to talk about international cooperation. First of all, to highlight the asset recovery processes when they are seized abroad. These are relevant for any criminal process or any infraction, and we should always keep it in our mind. And we are thinking about corruption and seizure and recovery of assets from corruption. But the important thing, the relevant, is to recover the asset that is connected to any activity that we have in this huge amount of infractions. And this will always be because of the financial profit of the perpetrator. So if we want to have an impact in the persecution of these infractions, we should look at the patrimony or the heritage of the same. They will always be available to retake the criminal activities. So in this way, if we manage to seize the physical authors, it is extremely important to have success in this type of criminal activity. The second point is the cooperation. Here it is also important to signal assets recovery as a process, and international cooperation is the same here. So the process of asset recovery has a number of stages, and to reach a final objective, which is to forfeit or to hold or to make sure that these assets can be returned to the country. And these stages are, as we have heard, the assets counseling and the seizure of assets and the recovery before they go back into crime. If this is internationally reviewed, generally speaking, and with cooperation, we also have the European Convention. And since in this convention the recovered assets are described as a process, I would like simply to formulate some reflections on this process that I think are important to highlight. The first stage is to the identification of an asset. This stage, it is crucial because the success of the whole process will depend on it. All the assets that are associated to this criminal activity we are investigating will have much more impact if we actually know what we are talking about. We can insure and we can freeze these assets. These can be sold and we need to recover them. So this stage, from this stage, the success of the investigation will depend. We will have a special relevance here on the international cooperation. It won't require only the part regarding the seized assets. Most countries in Europe, not all, but most of them, deny support in this process. You need a formal request that the public attorney can have a quicker access with a request to the country, and we'll accept this formal request because there is issue with a crime, with infraction, and then I will return the assets. So we need to activate and to identify all the assets in this country, and once this is done, there is a formal request so that I can freeze and seize these assets. Legislation itself and the working process is a short stage. We have here a concern before sending a formal request. We need to freeze them well, and there needs to be an identification process, and we've always said this could be done through Interpol. Relevant, what do I mean with this? It's the importance of the stage of the identification of the assets in abroad, all the formal mechanisms so that all this process is efficient. And with this cooperation mechanism, well, there are two that I believe are important. The first one is open sourcing. That is, it is crucial. It would be quite surprising on the way the police and the amounts of the quantity of information in open sources that we can find, namely in other countries, with information we can use directly in our criminal process. So the use of open sources is extremely important. And here, this is a normative reflection on regulations, on how to assist this source. We have Article 32 of the Budapest Convention against criminality that says if information is lodged in a server abroad, that information can be downloaded in anywhere else. So if I go into the open heritage source in Paraguay, I can download it and use it directly without asking for a formal request for the information to be sent. And here it is also important to highlight that there are certain there is a certain work that we're doing around the fiscal networks on corruption, namely with the assistance of ELPACT, so that all Ibero-American countries can have access to these sources of information and have access in other countries without the need for this formal request. So we can amplify this work and these sources to openly include it in these Ibero-American summits, which will have an important impact in the recovery of international assets. In Chile, this happens often that we find assets that are in Europe. So we will need to access these open sources, which will save us a lot of time. Another effort that we have envisaged is to have a first systematization that is absolutely open to the other countries. The second way for cooperation that we have heard about in the case of the UK is direct cooperation between competent authorities, such as the police, that through Interpol can have some type of specialization of a network within the Interpol that can help us in recovering assets. This will be assistance, financial assistance, for instance, interchange of data, intelligence, financial, and we could also use assets recovery transnationally if there is a way to introduce the part of intelligence in the criminal process. It's a network that is available and that can be used abroad. the use of specialized networks for locating and recovery of assets. We have the RAR, which is a network that we use in Latin America, and also the CARIB network in Europe. It could also be interesting to potentialize this relationship and to try and understand how Latin American countries can have access to this CARIB network. Here also from the perspective of a direct cooperation between the public prosecutors' offices to interchange information, to have access to have a lot of information both in heritage or assets that can be very useful to prepare an international request, and so that the asset will be frozen and seized, and then that they can be located in the territory. I would mention especially the agreements that have been signed in 18 regions in the International Ibero-American Assembly, and it could be important for this effect, that is to prepare formal requests so that the assets will be seized and frozen. Probably we will have some themes regarding personal data, namely in Europe, where we need to pay attention, but we need to create an effective way of collecting this type of information so that it will be effective and important internationally. Finally, just some comments on this process, always from the cooperation perspective, both in freezing the assets and when seizing these assets. In both stages, we need to see how can we execute or enforce the sentences of, as we call it here, the extinction of domains. It is very disseminated in Latin American countries. For instance, in other countries, for instance, in Chile, we don't have norms for an extinction figure. So it is a challenge for those countries that don't have these regulations to recover these extinctions of domain. This will become a challenge. How are we going to deal with this request? Is it a criminal or a civil aspect? In Colombia, we say that the extension of the domain is something mixed against the assets. So how can we put it within a house where we don't have any category created for it? We can have a solution or enforce directly international rules. There are different solutions, but I think it's important to highlight, since it is very important to look at this internationally. And finally, and not to extend my time a lot, sharing of assets. In Latin America, we usually we use the foreign offices and ministries on what is negotiated, what is given back, and what is not given back. It's very important to promote that those who have the investigation, who are in charge of investigation, that they have these powers and to know what they can deliver, because it's important to deliver them to the destiny assets. More than 60 to 70% will be given back, even even to compensate the victim, who is expecting to be handed back what was stolen, or society itself, which expects an asset that was retrieved to be given back. That is very important, and it will be in charge of these fiscals. And these are some reflections that I would like to introduce in terms of international cooperation. Thank you very much for the invitation, and I will pass the floor.
Thank you, Antonio, for your reflections. We are very lucky to hear you. This recovery of assets is very important. You left here some reflection and proposals, and from my perspective, very interesting. And I will start by the need to change the paradigm of this thought, and starting from the principle that all crimes are liable to generate profit. This is a very important thing in the recovery of assets. Also, the interesting reflections on the use of the evidence and relevant data on this matter, focusing in the international cooperation, which is very interesting. I think it's important to underline the possibility of cooperation and the challenges that exist in cooperation before the different typical modalities of committees that exist in different states, some without a sentence, to seek to investigate which are the most important parts in this method. It's a very interesting reflection and seems to be very valuable. Therefore, after identifying all these points of reflection, all these paths, all these suggestions for the creation of a new policy for the recovery of assets, I would leave to the participants the possibility of bringing here some contribution, some idea as a comment about this matter, about these topics, seeking to find together some solutions that will allow us to go against this lack of efficacy which regarding the recovery of assets. We have been able now a close rate to achieve the 100%. It's your time to intervene, to bring ideas. Those who want to make some comment or some intervention have a button that you should press in the microphone to ask for the floor, and this will be given to you. We are at your disposal for anything you might deem. Comment. I do not know if there's any comment, anything you would like to refer. There's a very interesting proposal that I think to have some result from this reflection, that is the need to consider the existence of two dimensions in the criminal proceedings nowadays. Not only there, but also in the fight, the profits gained by the criminals. Beside the criminal dimension, there's the assets dimension that includes the application of the mechanism for the recovery of assets. And going back to the initial one that we spoke, that all crimes are liable to generate gains, to generate products of a crime. And this idea that this assets recovery mechanism only are interest to those dedicated to the investigation of criminal phenomena that are more complex, such as organized crime or the economic or financial crime, that's completely wrong. The matter of the crimes where it's less likely to generate benefits like the honor crimes, which are also liable to generate benefits. But if I'm going to pay to gain 1,000 euros so that this person insults a player that made a goal against Portugal, so it determines the need to apply those mechanisms to all these crimes. So our focus cannot be in one sector. It has to be crossing, transversal to all these assets. It's a thought that I think is very relevant to associate this asset dimension to the criminal dimension, considering the need to establish two investigations, the criminal investigation that leads to the application of a sentence, and at the same time, the need to start an asset and financial investigation that will lead then to the assets accountability and the assets dimension of the infraction. And this could be used as a base for the creation of a new policy regarding the recovery office. So there's a culture of the recovery in order to create that culture. So I pass the floor now so you can intervene, make your contribution, and I hope that you have understood me while I was speaking Spanish, says the speaker, because he's Portuguese and he's speaking Spanish, and I hope that you understood what I said. Please collaborate, intervene in this matter, either with questions or just with comments and reflections. We are totally at your disposal. Now, as a contribution for such an important team, I believe that is transcendent, and I'm going to refer a thing that happened in Colombia that contributes to what has to do with the management of assets in those circumstances, based on the experience that we have, which was disastrous last years, which generated corruption in the management of these assets that along the years transformed into quite a load to the state due to the applications, the custodians of those assets, a web of corruption and condemnation against the state after many years. It happened in the 80s with the traffic of drugs, which some assets had to be returned, but when we were returning, the assets had disappeared. So there was a law either in 2010, 2018, says the speaker, and where we have the premature seizure, and it happens to allow that as soon as an asset has been confiscated or seized, it can be auctioned, and then a percentage, either 20 or 30%, is to pay the costs, and the other part is returned to the society, so that the police entity and another part to the Ministry of Justice to reinforce the justice action. I think that in Colombia we have a very important thing with the failure and with the errors, and then we made an assessment that can generate a revenue. And if tomorrow the judicial authorities determine that for some other reason an asset should be returned, then an assessment and evaluation is done, and then we return the asset. That person receives the 60%, and the other 30% goes to the state for protection. And on one end, it enables the management of the assets, the effective handling of the assets, and it prevents many actions of corruption in the management of these assets. So I think it's an idea that might contribute to improve the criminal laws in this matter. Thank you for your comments. I think they are very interesting. This notion of the importance of the assets management is very important, not only because it underlines the need to apply measures of assets guarantee, but also it's somehow the reflection of the maturity of states in this matter. And Colombia is a very advanced country regarding the recovery of assets. But regarding the management assets, it's a responsibility of the states, where the justice entities can play a relevant role, either in the change of good practice, knowing the practices of the different states. Another question. I think we have another question here. So you have the floor. Good morning. I think the three elements of the panel have posed very clear matters. So I'd like to address two problematic issues, and this will be a difficulty to solve it in the future. One of the problems that we have in this global dimension of crime and its punishable aspects independently of the financial ones, many times has to do with international legislations that are very different. We all know that this about the assets has different proportions, some similar, others very different, at least three different systems. In Spain, it's recognized as all relevant infraction. All others are serious infraction with all the definition of what is serious, and others have other infractions preceding there, which are considered severe or not. This laundry allows a dogmatic construction about the persecution of the property or the first operation. So the judges invented this kind of solution to persecute these assets and to freeze them without caring how many times they were recycled. We have the persecution of assets. Of course, for the laundry is one thing, and for the infraction is another. Different is not to be able to distinguish the drugs traffic with what is laundered, the traffic, other traffics, etc. On one hand, we have a dogmatic question that is presented with a problem to be solved in the future. Our Spanish friends are very pragmatic because in their legislation they have instituted some rules. We are not talking about previous crimes, and thus we save this discussion about preceding crimes. Other, which is not minor, we have discussed this many times, that in fact the asset investigation should be done in parallel with the investigation of the punishable crime. And there are different systems, of course, in Colombia with the dominion extension has created very good effects. I'm not going to talk about that. Or if the system we should have next would be like in Uruguay, in which the criminal proceedings leave that very clear. But the dominion extension, we might have difficulties regarding their recognition in abroad, and that's a problem that we should take into account for Germany. What is the definition that can be carried out by a tax officer? And also that recognition in abroad is a real problem that somehow might be for commissions abroad. So I would like to leave these two problems here and to underline that the Minister of Paraguay, these legislations are real. We have very advanced legislation, but in practice, that's what it difficult its application. In the Uruguay, we have anticipated system of assets recognition that can be the destruction, deterioration, and which would be that also can be as instruments and also as vehicles for the police. I think we are a bit late in that field, but it's necessary to implement that those assets can be destructed, can be deteriorated, or also there are intermediaries. There's also a joke that says that wants to use those assets that have been seized. They want to use those seized assets in a particular way, private way. So all the other sentences that might affect this kind of sentences, the difference between the laundry and other crimes within the laundry, there's several justifications. There's a lot of work to be done within this question. And if we could unify, we might advance in a more effective way. Thank you for your contribution. It's not by chance that these questions of the relation of the recovery of assets that have been seized comes up. It's an interesting reflection that should deserve our attention. In this matter of the differences in jurisdiction or differences in the mechanism for the recovery of assets, we might try to see the difference that really exists. We might also find here the points that are common, and that work can be done. And I think we have good perspectives in that sense. The laundry, it's a problem in the recovery of assets that has to do with the differences of jurisdiction, but the share of this recovery of assets, it's important so that for the case where both want the same objective. The laundry, it's only a reflection of the asset dimension of the criminal individual. This will originate in the first moment of that need to launder the money. Whenever there's possible that handling, there will be an handling, an autonomous handling in the launder. So it would be important to share the same objective. The laundering as the one objective to recover the profits of the crime in relation to the difference of jurisdiction, especially that field, that base where we can make the difference. And although many jurisdictions do not know different modalities, different mechanisms, such as the sentence for the extinction of the dominion, there might be common points in this issue. So we should ask if there are or not reasons to increase the trust in the states, especially there where there are no common laws. That trust is very important because trust is generated through the knowledge of the different jurisdictions, the differences of ideas in this matter. At least there's a set that should be transversal to all mechanisms. Either it's sentences and condemnation or sentences increased. Any of these modalities, all of them have at least a point that is common. And it could be there that we might base our trust. It's precisely in these references where we can use the matrix, where there is where there might be a previous crime as well as having an infraction. And this previous point in the criminal proceeding might be considered the issue of the dominion extinction if it's outside the criminal proceeding and is not legitimate. It's a illicit action. It's a punishable crime, and are causes for the exclusion of blame. At least from that starting point, we have the legitimacy of the cooperative measures based on the occurrences of a punishable crime, but are very important contributions, and seems to be two problems that will necessarily deserve deep reflection. I think there was another question. Another question?
Jorge Costa, please. Thank you very much. My name is Jorge Costa. I'm the General Director of the Directorate General for the Policies of Justice. I'm a magistrate for the public prosecutor for 37 years. I've been following these matters of cooperation, criminal and penal cooperation for many years.
Gostava de deixar aqui dois.
Although I'm not an expert, I would like to comment in 2 or 3 points on these issues. First of all, I would like to thank the organization, the invitation to be here. Also to thank all the participants on the table, because you have framed the issue in an interesting way regarding the recovery and the seizure of assets. The moderator, Dr. Elio, was talking about the eventual need for a new culture of assets recovery. I was also looking at the general theme, the identification of the general theme that talks about towards new policies in assets recovery. And I was thinking a little bit about the dichotomy between political culture or judiciary practice. That is, very often when we have a problem of enforcement, either at national or international level, to enforce the law, or problems or difficulties of interaction and collaboration, maxima at international level, we have, it is easy sometimes to say that it's a problem of the law and we need a new law. And usually that's a small sin that we have internally and sometimes externally. And it reminded me about what used to happen 20 years ago when at the level of the European Union, we were entering a new cycle regarding judiciary cooperation at global level. There are people here, namely Rosana Moran, that have been following this subject since then. And today I see the issue of assets recovery, namely within the scope of international cooperation, as 20 years ago we were looking at international cooperation in global terms. That is, we need to walk, but I think the starting point is already been taken. My ignorance, I don't know well the juridic framework of the Latin American countries. I promise to study it. But at the level of the European Union, I think there is no lack of juridical framework. I remember, and Elio knows about this much more than I believe that the Portuguese law from 2011, the first law, that is 10 years ago, and we constantly feel the need that we need to change the law. Coincidingly, I believe this weekend, the director of ICFES, which is the department or the body of the ministry where the department for management of assets is included, well, she sort of touched the wound, saying that there are still some problems to be solved. Of course, there are still lots of problems to be solved. But I think, and this is my personal opinion, I believe right now we have a juridical framework at national and international level to tread the path. Of course, as we walk, Fernando Pessoa, the poet, used to say that there are pebbles on the path and we need to overcome them. But as we tread our path, we can see insofar as policies should once more be included to once more create more advanced juridical frameworks that will be more evolved, for instance, in terms of the training of magistrates, the training of police, in creating joint teams that we've heard about this morning, joint teams, both in terms of the nature of solutions and in terms of the territory, that is police, magistrates of the public or general prosecution office, or do we need to go further away to meet the issue that Elio mentioned, which is new policies, new mechanisms? I believe that I would start by putting into practice the legal frameworks we already have, and also using a lot of what our colleague from Chile, Antonio Arancibia, mentioned, which is what is scarcely used in terms of international cooperation, which is non-formal cooperation. Non-formal cooperation, direct contacts. Elio was talking on a basis that the European Union is building for 20 years, which is mutual trust, which originates mutual confidence. And confidence and trust is created not by decree. And that's why I believe the institutions in Europe and Latin America should bet and should invest and should develop, which is trust. Only with trust we can take this path. Thank you, Jorge Costa, for your contribution. And it's correct, and I was mentioning that we could identify a number of problems. I don't think, at least in Portugal, I don't know much about the other jurisdictions, that the problem is the law. I mentioned that too. Right now, of course, if you ask me whether we have a perfect legislative model, maybe we can find another question that could be improved in the processual ways. But I think in terms of legislation, there is no problem that will hinder the application of these mechanisms. I was talking about the creation of a culture for asset recovery to change the judiciary practice. This paradigm that realizes that there is not only this as a consequence of a crime. There is a new dimension, which is the patrimony and the assets, and this must be put into practice through the effective enforcement of the mechanisms that exist. Of course, if they are insufficient, that needs to be noticed and signaled, and then it's up to the political power to change it. But I don't believe that is our problem. That is what the Ministry of Work was talking about. We have this need to create a culture of seizure recovery or recovery of assets that will be parallel to the criminal process. But it's a very important contribution. It's a path that we need to take. And after saying this, I would pass the floor once more to the Minister of Justice of Paraguay. I don't know if you have any comment you would like to add. or any contribution or even some question or a proposal for reflection. So, yes, thank you. Well, I believe there's lots of work ahead. Proposals are quite clear. We already understand where the difficulties are so that we can move on what regards the recovery of assets. Yesterday, we were saying that what happens in Lisbon stays in Lisbon, but not in this case. What happens here in Lisbon needs to overcome or to pass Lisbon and to become universal, or at least to Europe and Latin America. But if our work can be used in other regions, and I believe that will be the case, I think because one hand washes the other. So I have nothing else to add. Thank you. I think it's an excellent suggestion. Thank you, Minister, for your contributions once more. Antonio, do you have something else to add? Your intervention was very interesting too. I don't know if there is anything else you'd like to add as a consequence of what were the contributions we have heard throughout the debate. So please, you have the word. Well, thank you. Very shortly, I would like to thank all the interventions. They were all very interesting. There are two final ideas, I believe. One which I want to reiterate. The first one, which is this culture of recovery of assets that we've been talking about. There were different interventions on that. I think it's extremely important. If we want to have an impact in criminal investigation, we need always to consider this aspect, and for that we need to have very clearly defined everything which is related to the process, namely the recovery of assets and the patrimony issues, the creation and promotion of tools. That is very relevant. The second aspect is something that was mentioned by the last person who talked about the importance of to build trust between the different intervenants, because it's based on confidence and trust that international cooperation happens. And I believe that spaces such as these enable the reinforcement of trust, and we need to use these initiatives to have a more efficient cooperation in all the scopes. So thank you once more. Thank you, Antonio, for your contributions. We still have some time left. I don't want to stop anyone who wants to intervene to do it. So we still have some minutes left. So if anyone else wants to intervene, to add a comment or a contribution, or to raise any question, please feel free to do so. It's now the opportunity to do it. Antonio, do you have any contribution? No, basically, I just want to remind something. Each panel will be accompanied by its respective conclusions. So thank you very much, Hélio Rodrigues, and also everyone. Any consideration will be, Hélio will be the responsible to note it. And I think there is an agreement regarding this. Something I would like to underline, as I said in the beginning, there is no international meeting where you say that we need to recover the assets of a crime. I think that that comes in all idioms and colors. We need to internally assume that we need to take the step and pass from the word to facts, from words to facts. And what was mentioned before, Jorge Costa and the Minister of Justice of Paraguay, laws exist, they are there, they work. The problem now is culture. In the enforcement, in the practical application, and the need for national and international cooperation both in national spheres and international ones, that also need to be internationally articulated with also other international organizations. There is no culture if things are not put into practice. And I'm sorry, but laws are like great cars, but they need fuel. If we don't recover the assets, the system doesn't work. And then we have a fantastic Ferrari, but it's like having a bicycle or less. So these are not wagons pulled by animals. No, that's not how it works. This is an extremely important point, and we need to focus this. It is not enough to create a declaration, a statement that underlines the importance of assets recovery. That's been written all over in all the diplomas internationally. We need no more statements and principles on this. What is crucial and indispensable, and that's the major challenge, to establish a project and a number of commitments that can have as reference the practical problems and that looks for solutions, and a minimal commitment for future work. Underlining, of course, the need to improve the levels of trust in this way, because this will facilitate cooperation, namely where theoretical seizure of asset mechanisms are different. And probably it will be more indicated to look to what unites us, our common principles, those focal points that are common in asset recoveries, rather than differences that separates us. Looking at it differently and looking to what is common to all our jurisdictions, it could eventually constitute a future path in this area. With this, and if there are no further interventions, and if there is no one else who wants to intervene, I would like once more to thank the presence of Cecilia Pérez Rivas, the Minister of Justice of Paraguay, for her very relevant contribution. I would also like to thank Antonio Segovia and Silvia for his contribution with important reflection points, and everyone present for your attention and participation, and with reflection proposals that are so valid that I believe they will be accepted. Now I have the difficult job of gathering all these contributions and important conclusions. And it shouldn't be 100 pages. I believe that's too much. So once more, thank you everyone for that challenge that you have created for me, because it was thanks to your contribution and the richness of your contributions that have created this complex job I now have. But I'm happy because I think we've taken a first step, or we have put a first stone to build something which is so important in assets recovery. So once more, thank you everyone in this panel, and I'll be available for everything you need in this subject. Thank you very much, everyone.
¿Sí?